5 seconds to go. Start. As far as the 2010 notification is concerned, the proviso to section 14b introduced by the said notification confers deemed licensee status on SEZ developers. However, such conferment does not explicitly exclude the requirement of obtaining a license. This lack of specificity, especially when compared with the clear provisions for other entities, suggests that the legislative intent was not to ipso facto grant SEZ developers the status of deemed distribution licenses, thereby obliging them to obtain a license by making an application in terms of Regulation 13. TSERC is therefore empowered to scrutinize such applications in accordance with law, however, only limited to the provisions which are applicable to deemed licenses. Verification and acceptance recognize their status as deemed licenses. Issue B revolves around Rule 32 of the 2005 rules, which per the TSERC and the APTEL, the appellant is bound to adhere by infusing additional capital in order to qualify as a deemed licensee. While the appellant contends that the 2010 notification by necessary consequence grants upon the appellant the status of a deemed licensee, the respondents submit that the identification of the appellant as a deemed distribution licensee is conditional upon the appellant satisfying the other requirements of the Electricity Act, specifically the 6th proviso to section 14 of the Electricity Act, which provides for compliance with additional requirements like capital adequacy, which as per the respondents includes Rule 3 of the 2005 rules read with Regulation 12 of the 2013 regulations. It is contended by the respondents that the application of 2005 rules to the appellant, a SEZ developer, stems from the 6th proviso to section 14 read with Regulation 12 of the 2013 regulations. Let us now deal with the provisos to section 14. Upon a bare reading of the provision, it becomes crystal clear that not only does the 6th proviso, but none of the 9 provisos to section 14 apply to the appellant, a SEZ developer. Even the TSERC and the APTEL are ad idem with this view. The status of a SEZ developer as a deemed licensee emanates from the 2010 notification, which introduced the proviso to section 14b conferring deemed licensee status to SEZ developers. Reading anything beyond this would defeat the very purpose of the proviso and the concept of the deemed license. The 6th proviso does not pertain to deemed licenses, and therefore the 2005 rules are not applicable to the appellant. Upon closer examination of Regulation 12, it becomes apparent that its application does not extend to applicants who are otherwise deemed licenses. The interpretation of Regulation 12 as requiring additional capital infusion for an applicant for acceptance of a deemed licensee status appears to be at odds with the language and intent of the 2013 regulations itself. TSERC has, in essence, interpreted Regulation 12 by reading it up to mean that it also applies to a person who is a deemed licensee, and in doing so, the TSERC has aimed to achieve indirectly what it could not directly. Reading down and reading up are two principles often discussed in legal contexts, particularly in the realm of statutory interpretation. Reading down, which has been firmly ingrained in our jurisprudence, refers to the practice of interpreting a statute narrowly, limiting its scope or application to specific situations or individuals. This approach is commonly employed when the language of a statute is ambiguous or when there is a need to avoid potential conflicts with other laws or constitutional provisions. For example, if a law is unclear about whether it applies to certain types of businesses, a court may choose to read down the statute to only include those businesses explicitly mentioned in the text. Stop.